Welcome to Legal News and Review, recipient of the Florida Bar Award of Excellence, and featuring Michael Santucci, co-chair of the Intellectual Property Division of the Broward Bar. From the law firm of Santucci Priori, practicing intellectual property, business, and entertainment law and litigation, located in downtown Fort Lauderdale. Legal News and Review, the only real problem solver radio program using the law, with your moderator, Philip Bell. And hosts and legal panel attorney, Gary Singer, chair of the Broward County Bar Association's Real Property Section. Gary Singer is board certified in real estate law and a syndicated columnist from the Sun Sentinel. He is an expert in his field of practice. Now, here's your moderator, Philip Bell.
On the docket for today's broadcast, the U.S. Supreme Court recently came down with two decisions. One regarding patent trolls, and the other has to do with printer cartridges after they've been used. And this is a case regarding Lexmark. In the last 10 years, patent applications have more than tripled. Today, we're very pleased to feature board-certified attorney in intellectual property law, Rick Guerra, who advises his clients on litigation. He is a litigator as well regarding patent, trademark, copyright, and trade secret litigation. Rick is from the law firm of McDonald Hopkins. I'd first like to introduce and welcome our legal panel host. Good afternoon, Gary Singer.
How you doing, Phil?
You know, I'm doing pretty good. It's a pleasure that it's not raining for now.
Hey, Phil, I've ever told you how good looking you are? I just wish we were on video so everyone would know.
Move over there, Gary. And, of course, Gary Ostrow.
Great to be here. I concur with Gary Singer.
Oh, my goodness.
Someone's
hitting me up for dinner tonight.
Right.
You absolutely have a face for radio.
We need a loan.
And certainly not last, and or not least, but is last, Mike Santucci.
What?
Don't say it, Mike.
All right, take it back, Phil. I take it back.
The Santucci sandwich sitting between the two Garys.
I'm telling you. What do you keep us all saying?
A Santucci sandwich.
Hey, before we actually begin with the program, this is a great announcement. I mean, it does my heart good to be part of this. South Florida legal community is joining forces to host a mini golf tournament to help one of its very own find a kidney donor. Thompson Legal Services, with the support of the law firm of Arnstein and Lair, is hosting a mini golf tournament to raise awareness for the need of this kidney donor for Sandra Bolillo, a legal administrator with Arnstein and Lair, who's been with the firm now for, almost 30 years as well. This is going to be a great event, great networking, and you could do a lot of good as well. This will be Friday, June 16th, at the Miami Shores Country Club, 1000 Biscayne Bay, Miami Shores, Florida. Tee-off time will be 4 p.m., and golfers will play 9 holes of golf. The cost is only $75, but that includes the golf and 1 hour open bar. And that starts the open bar at 6:30. You taking notes, Gary?
Yeah.
Very good.
Which Gary?
I pointed both of you.
The one that needs to take notes.
As well. But please come out and support Sandy during this search. She goes through dialysis during the night and then shows up at work during the day.
That's brutal. I had a client that went through that.
It is.
It takes everything out of you.
And this was just presented to me this morning, and they asked me to help get it out, and we're very happy to work with these fine organizations, and we're going to be really doing a lot when it comes to social media and other things as well. You know, first of all, we have on the phone, not in person today, I'd like to say good afternoon, Rick.
Good afternoon, Phil. Thanks for having me, and I wish I could have been there in person.
Yep. Well, you know, you have a full docket, and we appreciate you taking the time. And these are some major issues that we're going to be talking about. And, you know, listen, if you've been around for generations, or even if you're a new company, you know, this is information you need to know, even though you don't know when you need it. Now, Richard, in the news was a decision by the U.S. Supreme Court, and this affects patent trolls. Briefly explain to our audience what this actually means and what's a patent troll.
Sure. Well, the troll moniker is something that can be, depending on who you're talking about, can be a little bit derogatory. So to be political, we often refer to them as NPEs, which stands for non-practicing entity. So whether you're being political or you just want to outright call them a troll, it makes no difference in the sense of what they are, and that is that they acquire the patent right whether it be through an auction or through a transaction with a private party. They don't necessarily manufacture, they don't commercialize the invention that's described in the patent. They simply take the patent and assert it against other entities, which is their right to do under the patent statute.
Rick, this is Michael Santucci, and I also litigate patent matters. I'm going to try to keep my soapbox on the side of the room today and not preach too much.
We're coming out in support of trolls.
Do you think there's been a bit of an overcompensation in the law and in the courts? Too much concern for patent trolls and too many protections that are put in place now against patent trolls, making it more difficult for an individual inventor to really police his or her patent against multinational corporations. What's your opinion on that?
It's a great question. I don't think that the regulations have been too extensive. Mm-hmm. And the reason being is Congress was not going to do anything in terms of changing the legislation to combat trolls, and it was for the precise reason that you mentioned. Congress had a very difficult time crafting what a troll or a non-practice entity was, because they didn't want to act in a way that would be towards the detriment of the independent inventor. Mm-hmm. So there wasn't going to be much changes, and we didn't really see any changes with the biggest piece of legislation reformation that we saw with the American Invents Act a few years ago. So in response and in reaction to that, I believe what's been happening is that the judiciary has taken the initiative to try and scale back the amount of filings that were coming through the dockets by these non-practicing entities. So you had a lot of court-created doctrines like the Alice court cases. Some was created through legislation, through IPR proceedings and post-grant proceedings, and I can talk about that a little bit more at length if you think it'll be beneficial. But ultimately, I think that the court was doing its duty in controlling its dockets, and that's why you see these cases coming down and these doctrines, these judicial doctrines being created to try to scale back the amount of filings that we were seeing in the past 5 to 10 years with these non-practicing entities.
So, Rick, this is Gary Singer. So, I think you make a great point. But if that's the case, then what's the purpose of legislation if the court's already handling it? Which, frankly, I agree that they were trying to knock it down back, but they clearly weren't handling all of the problem. Well, we wouldn't have needed this legislation, no?
We wouldn't need it, right? Well, I think it was a signal from the Article III courts to the legislature that, listen, if you're not going to do anything about this, then we're going to have to do something ourselves.
Now, so you think that's kind of what brought the legislation saying, hey, well, rather than let the courts decide, we'll decide?
Precisely.
Gotcha.
Rick, excuse me one second. Patent trolls is an issue, but it also brings business to litigators like yourself or even Michael Santucci. You had an interesting case that had exposure of over $850 million, and it was a very large medical, I'll say who it is, St. Jude, against NPE. And I understand that you did well. You got a summary judgment for your client. But wasn't that part of a patent troll issue?
Yeah, that the plaintiff in that case was what you would consider an NPE. They acquired the patent right, and they didn't commercialize, and they weren't competing. And they asserted that same patent against a lot of manufacturers for the same product that was at issue. And in that case, interestingly enough, when I talk about the various measures that were put into place to try and control and scale back the amount of IPR and NPE filings,
right.
That case ultimately was resolved favorably for our client, because an IPR, which is an inter partes review proceeding before the United States Patent and Trademark Office,
right,
was filed and granted, and it ended up invalidating the patent that was being asserted before the district court. So it's a very clear example of how these both on the judiciary end and then with the legislation that was created through the AIA has put certain stops on NPE's abilities to proceed with their cases.
Rick, this is Gary Ostrow. I just have a question about the what allowed these parties to forum shop and find these plaintiff favorable places like in Texas where they can file independent of venue considerations and jurisdiction? How were they able to do that without having to follow the rules that I'm familiar with? I'm more of a criminal practitioner, but I believe venue is always relative and relevant, and these guys are just forum shopping. How were they able to get away with that by virtue of what rules or procedures? I understand that's been amended since then, but what were they relying on by being able to forum shop before? If you understand my
question.
question.
So now we're getting into the case that the T.C. Heartland case that was recently issued by the Supreme Court. So prior to that case, and I don't know, it's yet to be seen what effect that case is going to have in the filings in the hot dockets like the Eastern District of Texas. But prior to that case, if you can assert personal jurisdiction over a defendant who's being accused of infringement, it was enough. So if you ordered a product, and I've done this before on the plaintiff side as well, or the defense side, where you order a product and you do your analysis of the accused device or method. But if you order the device and had the company sell into the jurisdiction, then from a general civil standpoint, you're familiar with the differences between general jurisdiction and specific jurisdiction. If you sell the device that's ultimately accused as infringing in the complaint, then you can have a good shot of attaching specific jurisdiction.
So they would arrange to make that purchase just to have that jurisdictional advantage, right? I mean,
you got it.
Sounds like a little bit of a sham.
You call up, you tell your paralegal, hey, go online and order this for me.
Wow.
It was flying here in the Southern District of Florida too. Not only on patent cases, I see that on trademark cases as well. And I have to say, I've also done it. Hired investigators, make a couple of purchases, and then you send your cease and desist letter or a complaint. So. Yeah.
And the T.C. Heartland case is, it looks like that's going to change the landscape. So it's not only, it's no longer as broad as the general jurisdiction for personal jurisdiction. Now you have to have a defendant who is either domiciled in that state or has a significant business interest in that state.
You know, we're going to have to take a quick break here. You're listening to Legal News and Review. I'm Philip Bell, along with legal panel host Gary Ostrow, Gary Singer, and, of course, Michael Santucci. And we're speaking to Rick Gierup, and Rick is from McDonald Hopkins. He's board certified in intellectual property law, and that means the bar allows me to call you an expert, which you actually are as well. And coming back, we're going to talk about the Lexmark decision. That's where they take those cartridges and refill them, and apparently you can do that without any ramifications. We're going to be coming right back.
Today's broadcast is brought to you in part by Corporate Capital Direct. Listen, banks are not lending, and the online lenders may not tell you all you need to hear to make the right decision for your company needs. Get the inside edge for business financing. Whether you have capital needs for inventory, payroll, general operating expenses, or even to consolidate expensive debt or tax issues, Corporate Capital Direct can help you avoid common mistakes when seeking a capital solution for your business. Never upfront fees. Get the inside edge for your business financing needs. Call Corporate Capital Direct at 800-261-6478 or go to corpcapdirect.com. Again, call Corporate Capital Direct at 800-261-6478 or go to corpcapdirect.com.
Welcome back to Legal News and Review. Recipient of the Award of Excellence from the Florida Bar, featuring Michael Santucci of the law firm Santucci Priori, practicing intellectual property, business, and entertainment law and litigation, located in downtown Fort Lauderdale. Reach them at 500law.com or 954-351-7474. To contact the legal panel hosts and guests, go online to belegalbuzz.com. Once again, here's your moderator, Philip Bell.
Legal News and Review is back on the air. I am Philip Bell, the moderator, along with legal panel host Gary Ostrow, Gary Singer, and legal panel host Michael Santucci. And we're talking to Rick Guerra. And Rick Guerra is a board-certified attorney who practices intellectual property law. Matter of fact, that's what he's board-certified. Am I correct, Rick?
That's correct.
So got something right here. It's actually right in front of me. And you relayed an interesting story to me regarding the Lexmark case. And I'd like you to explain to the audience what the Lexmark case actually is and share the interesting story. I got a kick out of it when you told me about this.
Oh, right. So, right, with the Eastern District, with the Southern District of Texas. So the Lexmark decision was a Federal Circuit opinion. And let me take a step back. There's a doctrine in patent law known as patent exhaustion, the first sale doctrine, which means if I sell my patented product to the first buyer and consumer, and the product continues to be sold downstream, that doctrine protects the downstream buyer from infringement to a certain extent. So Lexmark, dealing with these ink cartridges, in the Federal Circuit level, the holding was that if there were certain restrictions in the resale, in the agreement that governed the resale, then the downstream consumer would not be protected by the doctrine, which means that if it was resold downstream to a third party that the patentee was not aware of, then they would have the ability to go after them for infringement. That case was overturned by the Supreme Court last Tuesday, and the funny anecdote to that is I was sitting in a bankruptcy court in the Southern District of Texas with an issue that involved patent exhaustion. And this was on the Tuesday that the Supreme Court rendered the decision. And I had the Federal Circuit decision in front of me, ready to just, tear into the other side with why the patent exhaustion principle didn't apply in our case because we had restrictions on the resale. Right. And after the fact, I had my partner who was there with me say, by the way, you realize the Supreme Court just overturned that decision this very day.
The attorney, you're making all the attorneys laugh about that.
I became very familiar with Lexmark for the days preceding. Luckily, it didn't have an effect.
Great timing.
Yeah.
As a litigator, when it comes to intellectual property law issues, you cover the whole gambit from trademarks to even patents, of course, and trade secrets. I mean, there's nothing that you don't cover when it comes to IP law. Is that correct?
That's correct, especially being down here in South Florida. Before I was with McDonald Hopkins, I was with a boutique intellectual property law firm. Down here, you really need to broaden your set of skills in the IP market. It's difficult down here to make a name for yourself if you're going to be very, very specific. So through the years, I've learned to do not only the patent side of it, but the trademark, copyright, and the trade secrets.
How much of your time is spent litigating versus prosecution, like patent prosecution, trademark?
It depends. It just depends on what's coming in and where you are in the cycle. Prosecution, I tend to not, and just for the audience, prosecution, we're talking about the actual drafting and getting patents and trademarks obtained through the United States Patent Trademark Office,
as opposed to the type of prosecution done at the state attorney's office.
Right? Yeah.
None of that. You don't get involved in that.
I think that it's very draconian. So this is administrative work before a government body in Washington, in D.C. It's usually about 70-30, but it sways back and forth depending on what the flavor of the month is.
But when you get a case that comes to you, what sort of due diligence do you need to do in order to know that this is a case you're going to take on? And what I mean by that is, let's say it's a patent infringement, and I see some guy selling the same product at a trade show. How can I protect myself? How do I know that maybe I'm infringing and not him?
Well, there's a couple of when you're dealing. It depends first of all on how savvy is the client in terms of their knowledge of patent law and how it works. So you use the example of the guy at the trade show, right?
Right.
If you're talking about a bigger company, a Fortune 500 that knows the ins and outs, and you're dealing with a general counsel, then your role is very well defined, and they can come to you and they can say, look, we've been accused of X, Y, and Z. We need you to do a freedom to operate opinion. We need you to vet some of these patents and see whether or not there's a risk and create a risk profile for us. If it is more of a mid-level or a sole proprietor, which my firm is happy to represent those just as much as they are Fortune 500s. But if it is that type of client, then you need to sit down and go through the one-on-ones with them. And you need to explain to them certain basics that are not always apparent when people hear patents. One common misconception that I always get is they feel that they need the patent in order to commercialize and go to market with their product. And I have to explain to them immediately. A patent it is what is known as a negative right. It prohibits others from encroaching on your intellectual property, but it really has nothing to do with your ability to go out and sell. It's nice to have patent pending on there, and it could increase your market value on there, but it's not necessary. So the first thing I do in vetting that a potential client and a potential case and matter is to understand what is the depth of knowledge that client possesses, first and foremost, and then fill in the blanks for them so that they have an understanding of what their ultimate goal needs to be.
In the 20 years that I've been practicing, I just noticed there's a bit of a shift. I just find there's more sophisticated clients today in terms of intellectual property. There's a more of an understanding of intellectual property out in the public consciousness today as there were maybe 20, 25 years ago. And here's just one example. It's just a great show on HBO called Silicon Valley.
Oh, yeah.
This season they had an episode called Intellectual Property, and another episode. This week's episode was called Patent Trolls. Yes,
right. With the copyright, yeah.
Yes, funny show.
But how is unique when you are giving a presentation to the patent office? It has to be unique, correct? It can't be like a similar idea.
Right. There's several requirements that have to be met, and one of them is novelty. So you have to have novelty. You have to have non-obviousness, and the difference between those, it can get a little bit complex depending on how much prior art is out there and how crowded the field is for the particular technology. And then another requirement is, which is the hot one right now, is that it's got to be eligible for subject matter patentability on your basic 101. Right now, the software industry is under attack for a lot of, and I shouldn't say the industry, but rather individuals that are asserting patents, software-related patents and claims are under attack by U.S. Supreme Court and Federal Circuit decisions trying to cut down. And again, this is what we initially spoke about, is judicially created doctrines that are cutting down, saying these types of patents are simply abstract and they don't meet. So it's beyond novelty. It doesn't even get to novelty. It might be novel and it might be new and obvious, but it doesn't cut the initial requirement of being patentable under Section 101.
You know, Rick, I wish we had more time. I'm going to invite you to come back physically. You can't do it by phone again. You got to be here, and we're going to do some follow-up on that and the issues that surround patent litigation. You know, it doesn't matter if you got your name from the state. It doesn't matter if you got a domain name from GoDaddy. You may be infringing on people's intellectual property rights as well. Gary?
Well, that's a great week, Phil. It's very interesting stuff. I just want to say that you'll always be my patent troll, Phil. On that note,
So good of you.
How does somebody reach Rick Guerra?
yeah, that's a good question. Rick, how do we reach you?
You can Google me, McDonald Hopkins,
I barely know
Richard
you.
Guerra, and you can always email me on rguerra@mcdonaldhopkins.com.
How do you spell that? R-G...
R. Guerra, Guerra.
All right, perfect. Mike, you have anything else?
That's it. I wish we had more time. Thanks, everybody, for listening. If you are in the car, please put your phones down. There's plenty to listen to on the radio. And always remember, be legal.
You've been listening to the award-winning Legal News and Review, recognized by the Florida Bar's Award of Excellence. Legal News and Review, featuring Michael Santucci from the law firm of Santucci Priori, located in downtown Fort Lauderdale, and practicing intellectual property, business, and entertainment law and litigation. They can be reached at 500law.com or at 954-351-7474. To contact the legal panel hosts and guests, go to BeLegalBuzz.com. And to reach Gary Singer, board-certified real estate and syndicated columnist, appearing in 400 media outlets, including the front page of the Money section every Monday in the Sun Sentinel, from the law firm of Gary M. Singer, PA, call 954-851-1448 for legal news and review. Remember, be legal.
Today's broadcast is brought to you in part by Corporate Capital Direct. Listen, banks are not lending, and the online lenders may not tell you all you need to hear to make the right decision for your company needs. Get the inside edge for business financing. Whether you have capital needs for inventory, payroll, general operating expenses, or even to consolidate expensive debt or tax issues, Corporate Capital Direct can help you avoid common mistakes when seeking a capital solution for your business. Never upfront fees. Get the inside edge for your business financing needs. Call Corporate Capital Direct at 800-261-6478 or go to corpcapdirect.com. Again, call Corporate Capital Direct at 800-261-6478 or go to corpcapdirect.com.